A person or every person shall be entitled to his personal liberty, and no person shall be deprived of his personal liberty except in the following cases and in accordance with procedure permitted by law: in execution of a sentence or order of a court in respect of a criminal offense of which he has been convicted, or in execution of an order of a court punishing him for contempt of court, or for the purpose of bringing him before a court in execution of an order of a court, or in the case of a person suffering from an infectious or contagious disease, a person of unsound mind, a person addicted to drugs or alcohol, or a vagrant, for the purpose of his care or treatment or the protection of the community, or for the purpose of the education or welfare of a person who has not attained the age of 18 years, or for the purpose of preventing the unlawful entry of that person into Ghana, or of affecting or effecting the expulsion, extradition, or other lawful removal of that person from Ghana, or for the purpose of restricting that person while he is being lawfully conveyed through Ghana in the course of his extradition or removal from the community, from one community to another, or upon reasonable suspicion of his having committed or being about to commit a criminal offense under the laws of Ghana. I repeat the preamble. It says, a person shall be entitled to his personal liberty, and no person shall be deprived of his personal liberty except in the circumstances I have read to you. That is Article 14, Clause 1. Clause 2 says, a person who is arrested, restricted, or detained shall be informed immediately in a language that he understands of the reasons for his arrest, restriction, or detention, and of his right to a lawyer of his choice. Clause 3. A person who is arrested, restricted, or detained for the purpose of bringing him before a court in execution of an order of a court, or upon reasonable suspicion of his having committed or being about to commit a criminal offense under the laws of Ghana, and who is not released. If you are arrested, restricted, or detained for whatever purposes as established by law, and if you are not released, you shall be brought before a court within 48 hours after the arrest, restriction, or detention. We talk again about bail. 360. The last time we spoke about bail 101 with Martin Pebu. We'll be right back to get into the details. This is the law. It's your legal light. It is your help law. I'm Samson Ladia Nyanini.
Bailing is like someone guaranteeing an inmate or someone in cells or prison for the person to come out for some time.
Bail is all about like bailing someone from out of the cell, or you can rescue someone from out of a kind of issue or a kind of problem. Yeah, just to set the person free.
Bail is like you're going to guarantee for somebody to be free. That's all I know.
What I understand by bail is going to stand as a guarantor for the person to be released from the police station.
Okay, when you talk of bail means like you, the guarantor, you have to go into the police station, and let's say maybe they put some fine on maybe the person who has become the listing. So they put the fine on maybe 100,000 or so that if the person didn't come or they didn't see the person, that person who was.
You're welcome back. This is the law. It's your legal light. It is your help law. And we are dealing with the matters of bail. The law says a court shall refuse to grant bail in a case of treason, subversion, murder, robbery, hijacking, piracy, rape, defilement, or escape from lawful custody, or where a person is being held for extradition to a foreign country. And if you were being held for narcotic offenses and terrorism, you were not liable to be considered for bail. The police cannot think about giving you bail. The court cannot think about giving you bail. That was some time ago. But Martin Kpebu went to the court, the Supreme Court, and argued that every criminal offense must be subjected to bail. And the Supreme Court agreed with him. So today, because of Martin Kpebu going to the Supreme Court and making this argument before the court in 2015 and 2016, now there is no offense in Ghana for which, if you are arrested, you are detained, you are restricted, or you are arraigned before a court, you will not be subject to bail, except the bail is not automatic. The bail is at the discretion of the court or the institution, the law enforcement institution that is arrested you, restricted your movement, or is detaining you. Every offense, including the former offenses of that were not bailable, like treason, murder, subversion, hijacking, piracy, defilement, rape, all of those are subject to bail, but at the discretion of law enforcement and the courts. So, how do you go about securing a bail, and how do these institutions, including the court, determine how bail has to be worked on? Gideon Lawrence, we're opening the phone lines in due course so that you also join us. My guest joining us, Daniel Krang. Daniel Krang is partner at Dome Legal Consult. He's an author of several legal texts that we use and read. Isaac Kankam is head of Kankam at Law, will also join us. And if we're lucky, Musa Ahmed, head of Ahmed Legal Consult. He's not stranger to the show, will also join us. I understand all three are with us. Gentlemen, good afternoon, and thank you very much for making time to join us. Hello.
Hello.
Great. That's Isaac's voice I hear. Hello, Daniel and Musa.
Samson, good afternoon.
Good afternoon. All right, so Senior Musa, you will have to unmute. Thank you very much. Thank you very much. Right. So let's begin this way. Daniel, for basics, very basics, begin with us and explain to us what exactly is bail.
Samson, for having me this afternoon, and a very good afternoon to your cherished viewers and those still listening. When we talk about bail in criminal law, we are talking about the fact that anytime a person is alleged to have committed a crime and that person is arrested by the state through the police or the EOCO officials or the person arrested is said to be in lawful custody. What lawful custody means is that the state has lawfully taken that person into custody, and by that, the freedom of movement of that person is legally restricted. And so the person is restrained. Now, the state has the power under the law to hold on to the suspect until such time that the law permits. So during the time that the person is in lawful detention and custody, the law permits that person to be released on bail, to be released and to be set free to move about. So bail means that somebody is providing sufficient security to guarantee that when this suspect is released, that suspect would return to stand trial or to participate in further investigations and prosecution. So
Right.
bail simply means releasing a criminal suspect who is being held in lawful custody to move about and to be set free, subject to provision of sufficient security, either by the person himself or by a third party, to guarantee that when this person is released, he will not abscond or run away, or he will not commit further crime, or he will produce himself to subject himself to trial.
Right.
So this essentially is what bail is all about.
Thank you. So, Senior Musa Ahmed, there are circumstances we hear that the bail is granted on self-recognizance. What does that also mean? Does that mean there's a guarantor involved?
No, thank you, Samson. When we talk about self-recognizance, you see that the expression self means that you in person, the accused person, you are granted liberty or the opportunity to sign the bail conditions by yourself on your own with conditions or subject to conditions, so that you don't have a third party coming to stand surety for you. The state believes that looking at you, maybe you are a member of parliament, you are a member of the executive, you are a prominent person, you are a chief, you are an important person. So the law presumes that you will not run away or you will not abscond when you are allowed personally to sign the conditions of your bail so that no third party comes in. That is what we call self-recognizance bail.
We also understand, and your Zoom is very clean, I just love it. We also understand that you could get bail where the surety is to be justified, and in certain circumstances, there's no justification. Can you help us understand the two?
Yes. When bail is said to be justified, it means that when they set the conditions, they will tell you, for instance, you need to provide security in the sum of 50,000 Ghana cedis, 100,000 Ghana cedis, or 20 million Ghana cedis. Now, when the condition is set, it means that to be justified, the person who is coming to stand surety for you must produce evidence of a sufficient property which is equal or more than the amount of money that has been set for your bail. That is what we call to be justified. But not to be justified is like a wholesale. The conditions are set all right, but they need somebody who is responsible enough and he is known to be of a person of repute or character to come and sign for you so that he doesn't justify that he or she has a property valued more than the amount or condition that has been set for your bail. So that is the difference.
Right.
One, you have to justify with a quantum of a property. The other one, you don't have to justify.
Right. I can come. When we say it is not justified, the people I am bringing to stand surety, practically, what are they required to do when you, the lawyers, call them to come and stand surety for the person who has been arraigned, as we say, the accused person or the suspect that has been put in police custody or has been taken to court, and you say someone should come and stand surety for them, and they are not going to provide justification for it? Normally, practically, what do those people do, the guarantors?
Well, Sam, thank you. In practical terms, when there's no justification, what it means is that the persons, first of all, are people the system can say that they are persons of good repute. They are persons that when we are looking for them, will not have a lot of issues. So what it means is that, for instance, if somebody is a chief in his community or his society and someone has been arrested, and the chief shows up to say that I will stand as surety for you. Because of the chief's status in the society or community, the police or the law enforcement can say that, now you can sign, not necessarily bringing justification. So that is what it means. So when there's no justification, then the reputation and the status of the surety is something we cannot question. But we should also forget that that is also determined by the kind of offense that is committed. Yes, because if the offense, the gravity will determine, it is always the gravity that brings in the question of justification.
Right, but in everyday, situations when we go to the police or we are in court and they say you are granted bail, there's no justification, all the court requires or the police will require is for you to show your ID and for them to inspect your property. Is that it?
In that sense, they may want you to come with your Ghana card. Then they will make photocopy of the Ghana card, attach it to the bail documentation, and then you will sign. That is it. They may also have to at least inspect your place of residence to be sure that whenever we are looking for you, they could find you. Yes.
Right. Daniel, when they say it's to be justified, is it always about a house or a land? Is that the case?
Thank you very much, Samson. You see, anytime somebody is in detention and there is a need for that person to be admitted to bail, crime involves some money. It may involve some money. So the bail condition or the bail amount will be set above or equal to the bail sum. So when the bail condition is such that it is to be justified, then we will need evidence of the value of a property that is either equal to or is more than the amount set. And so what we usually do is we would go for landed properties like houses or anything that is a landed property. But it could also be that the person has enough money in his account or the surety has enough money in their account to say that I am giving this in surety or to assure the person's reappearance. So it is not always about landed property. It could be any property of whatever description. What is of essence here is the value of that property. And sometimes the court is able to determine or prescribe what property should be used. The court can say we need only landed property. Those are also matters of discretion for the court. And so it is not always about a house or a landed property. It could be any property of whatever description.
Right. So, Musa Ahmed, I want to find out if you want to say anything briefly about these conditions that are normally determined. We want to find out, is there any other way the conditions are determined, apart from, say, the thing that the offense that you are alleged to have committed, it involves money, or the value of what you are dealing with is about 100 million. So we say we put a bail of the same amount or above that amount, which you said earlier. How are the conditions determined?
Yeah, you see, in the first place, the condition is subject to the discretion of the honorable court. So they will be looking at certain factors, such as if the person is not a flight risk, if the person is not likely to interfere with investigations, if the person is not likely to interfere with witnesses, if the person doesn't have a history of not appearing when he is granted bail. There are so many conditions, and it, as I said, is subject to the overriding discretion of the honorable court, because the court will determine. But mind you,
of the
main
court
focus
or the arresting institution, right?
is that yes, if it is a court bail, if it is a police or the arresting institution, then they have a discretion. And that discretion is also subject to Article 296 of the Constitution, that you have to be fair, you have to be candid, not capricious, and not arbitrary. You have to be fair and just. Okay? So, but mind you, the main purpose of bail is to ensure that you, the accused person, as and when you are required to come and stand trial, you appear in court.
Right.
So any condition that will be put in place to ensure your attendance to court is what the court will be looking for.
I'm holding in my hand Justice Dennis Ajay's book, Criminal Procedure and Practice in Ghana, the second edition. And he says at page 172 on bail, and he says, I read, that the amount and conditions for bail shall be fixed by the court, taking into consideration the circumstances of the case, and shall not be excessive or harsh. It is wrong for a court to refuse bail or make it harsh and excessive with the aim of punishing the accused. Similarly, a court shall not withdraw a bail granted without any justification according to law. What does this mean? Starting with you, Musa Ahmed.
Well, it's very simple. You see, here is a person who has gone to commit an offense involving a value that does not exceed 2,000 Ghana cedis. Now, it means that what the victim is losing is about 2,000 Ghana cedis. And the punishment is also, let's say, 6 months. It will be harsh on the part of the court to say that such a person shall furnish security in the sum of 20 million Ghana cedis. That will be too harsh. Because what the court is seeking to do is to impose a sum or a condition that will be very difficult for the accused person to meet. Or the person, sometimes some of the judges will tell you that, look, we need 2 civil servants who are receiving not less than 40,000 Ghana cedis as their salary every month. Both of them to come and sign as surety for you. If you look at the offense, and as I said, the offense, the nature of the gravity, the gravity of the offense or the nature of the offense and the punishment thereof shall determine the condition for bail. So the judge, in his discretion, should not impose a condition that is so outrageous and unreasonable and above the punishment for the offense or the quantum of what has been lost for that offense.
Right. And Isaac,
Yes.
so here is the law saying that bail shall not be used as a punishment. And where the bail condition is excessive or is harsh, it is deemed to be that the bail has been used as a punishment. If that happens, what can the accused person or the suspect do?
Yes, Sam, thank you. When the condition is set and it is seen to be harsh, the only option before the court is to go on an application for review or variation of the bail condition. So bottom line is that if, let's say, just as my colleague said, the offense is for the theft of an amount of 2,000, and where instead of bail condition that ultimately is more than the 2,000, then you may have to go back with an application for a variation of the bail condition. So you convince the court that you set ABC as a bail condition, but the applicant has made efforts. Still, he has not been able to meet the bail condition. So you are asking the court to vary the bail condition to something that is less harsh, something that the applicant or the suspect can meet. So sometimes you, as the lawyer for the applicant, can even propose some less terms that, in your view, if the court says that your client, let's say the condition is for justification, can go back to the court and try to convince the court that, looking at the offense and the circumstances in its entirety, if you think that the court takes away the justification and then makes it just bail condition simplicity without justification, then the court can consider and vary the bail condition.
Right. As we just saw, and we are screening one of the headlines of a recent story, you will see that the High Court revised Edubuahin's bail condition to 80 million Ghana cedis. The police had set it at 120 million Ghana cedis. So they went to court and they made an appeal to the court, and the court revised it from 120 million Ghana cedis to 80 million Ghana cedis with two sureties, one of whom was to provide justification. And Musa Ahmed has already explained that when they say there's justification, it means you are not just coming with your ID card to show yourself and then perhaps they go and check your residence, but you must bring documents to property with that value, documents to property of that value. And Daniel Kran had stated in addition that money could also be used. We will have to explain that because in Ghana, as you know, generally we say when you are being granted bail and you are being asked money, it means something wrong is happening. So what will be the circumstance under which you will have to use money or a check or some investment, evidence of investment to secure a bail? Right. Thank you very much. This is the law. It's your legal light. It is your help law. My guests that are helping us appreciate the law, Musa Ahmed, not a stranger to this program. He is head Ahmed Legal Consult. He's a very senior lawyer. Isaac Kankam is head of Kankam at Law, and Daniel Krang is partner at Dome Legal Consult, far away in Siani. And he's the author of several legal texts, including criminal law texts. So I want us to first appreciate, help our viewers to appreciate this. When the Constitution, the provision I read, Article 14, particularly Clause 3, says a person who is arrested, restricted, or detained, and who is not released shall be brought before a court within 48 hours after the arrest, restriction, or detention. What does this entail? Daniel.
Thank you very much, Samson. The provision of the Constitution that you just read, that is Article 14, Clause 3, has come to be notoriously known as the 48-hour rule. When we talk about the 48-hour rule, it is part of the bundle of human rights that a criminal suspect enjoys. And what it simply means is that anyone who is arrested and detained cannot be held in detention for more than 48 hours without being produced before a court of competent jurisdiction. And this provision, if I should say, applies to non-court bails. Non-court bails. You know, we have court bail, then we have police bail or bail that is granted by arresting institutions like IOCO or the police. When the police arrest a criminal suspect, they have the discretion to hold the person in detention for so many hours, but never beyond 48 hours. So when the police do not have any reason to release the person on bail, the Constitution says that they must take steps to produce or arraign the person before a court for necessary actions to be taken regarding bail or remand. And so anytime the police do not release a criminal suspect on bail, they have to ensure that that person is not held in detention for more than 48 hours. Now, when the police, the difficulty is when the police have granted bail to the suspect, but the suspect has not been able to meet the bail condition. So technically, the person is on bail, except that the person has not met the bail condition.
Okay, now hold on there for me, and hold on there for me.
The police cannot let 8 hours without release.
Okay, hold on there for me. Your line 2 is not that helpful. But Musa Ahmed, when the person has been granted bail by the arresting institution within 48 hours, and that person is not able to meet the bail conditions, must the police not still present the person before the court?
That is an interesting question. But you see, Article 14 of the Constitution is part of the supreme law of the land. And any other law or action that contradicts Article 14 shall, to the extent of the contradiction or inconsistency, be void. If the police grants you bail and you are not able to meet the condition, I wouldn't term that failure to meet the condition to have violated Article 14 of the Constitution simpliciter. The only time that one would argue or could argue that Article 14 would have been infringed is when they impose unreasonable conditions, which would in effect amount to a refusal to grant you bail. If the police insist on conditions which a court of law or a reasonable person would conclude that it amounts to a refusal, then in that event, bail is deemed not to have been granted within 48 hours. In that event, the police must submit the person to court for the court then to determine the bail conditions. But as I said, if in the opinion of a reasonable person or a court of law, the conditions they have set, for instance, they grant you bail, self-recognizance bail, and you refuse to sign. You say, look, as for me, I will not sign in person. In that event, nobody can say that the police has granted you a condition that amounts to a refusal to grant you bail. Or in the alternative, you are somebody who knows a particular civil servant in your family, and the person is willing to sign bail. They bring the person to the police station, and you say that, look, as for this, my uncle or family member or friend, I don't want him to sign bail for me. One would understand that you, the accused person, you are being unreasonable with the conditions set for your bail. In that event, if you don't sign and you stay in custody for more than 48 hours, you cannot accuse the police of having violated Article 14 of the Constitution, because in that event, you were given every opportunity to avail yourself under Article 14 of the Constitution, but you failed to do so. So we have to make a distinction between conditions which may amount to a refusal and reasonable conditions which may not amount to a refusal, to determine whether or not
the terms of Article 14.3b are these. Article 14.3, not B, Article 14.3 is that a person who is arrested, restricted, or detained shall be brought before a court within 48 hours after the arrest, restriction, or detention. But before it says the person shall be brought before a court within 48 hours after the arrest or detention, it says if that person is not released. So if you have been granted bail by the police and that bail has not led to your release, why should we be making a distinction between one that is excessive and one that is not excessive?
You see something? The point is this, that we should not carry the meaning of Article 14 too far. It starts by talking about who is not released. Who is not released?
Yes.
The question is, who is not released?
Shall be brought before a court within 48 hours.
A person who is not released is a person who has no option to secure his own release by providing conditions. But who is not released is not a person who has refused to take advantage of the liberty granted him by Article 14 and turns around to complain against a violation of Article 14. Because you see, there is a famous quotation that says that bail is not a privilege, it's a right. Okay? You have been given the right to exercise, and then you fail to take advantage of the right. Who do you blame?
I'm a poor person. You give me bail to say that I should look for two people. There's no justification. I simply can't find the two people.
That's right.
And I am still in police detention. That means I have not been released. So you should take me to court within 48 hours.
So, you see, that is why I made a distinction. The example you are giving would have applied to somebody who did not have the capacity to provide those conditions, and that would amount to a denial of bail.
Okay, hold on there quickly for me. Yes, Isaac, what do you say? The law says if the person is not released while in detention, restriction, or has been arrested by the police or any law enforcement agency, they must be brought before a court within 48 hours. How can you tell me that you have granted me bail, I have not met the bail conditions, I am still in your custody, but the police or whoever it is should not bring me before a court within the 48 hours? Hello, Isaac.
Well, Samson.
It's Isaac. It's Isaac's submission. Yes. I'm calling for now. Yes, Isaac.
No, I was going to give you an example, but
what I'm saying
you
is
let
that,
him finish.
What I'm saying is that, you see, the law enforcement agency, i.e. the police, is on the other side of the divide. So if they impose any condition that you are not able to meet, and you are still within their premises or you are still in their custody, beyond the 48 hours, they should not rely on the fact that you have been granted bail, you have not been able to meet it. They should still send you to court for the court to determine whether you are entitled to bail or not. Because, mind you, they are the ones who arrested you. So if they decide to impose onerous bail conditions or terms on you, and you are still within their premises or in their custody, I find it as a fetter on Article 14. It is purely against the intendment of Article 14. So I think that beyond the 48 hours, if you have still not been able to meet the bail condition, the police or the arresting institution should send you to court for the court to determine whether you're entitled to bail or not. So that in a situation where they decide to impose very harsh and excessive bail condition just to satisfy their interest, that can be taken care of by the court, because the court is the only independent arbiter. The police is the one that arrested you. If they decide to impose such conditions so they can continue to keep you in their custody, I think that it is wrong beyond the 48 hours, or even within the 48 hours, if you are still not being able to meet the bail condition, they should send you to court for the court to determine whether...
So if I understand you, Isaac, what you're saying is that it doesn't matter whether the bail condition given by the arresting institution is excessive or not. To the extent that within 48 hours, by the expiration of the 48-hour or within 48 hours, I am still in their custody, they should go to a court. They should take me to a court.
Especially where it goes beyond the 48 hours. If it is within the 48 hours, then it could be justified legally. But the moment you go beyond the 48 hours and you have not been able to meet the bail condition, I do not see that there's any legal grounds for the police or the investigative body or the arresting officer or the body to continue to keep you. So that we will take away this situation where they decide to impose conditions just for their own interest and still continue to keep you. We should not be seen, they should not be seen saying that, oh, we have given him bail conditions. We have given him bail conditions. What are the conditions? Is it onerous? Is it excessive? Is it harsh? Let the court determine. So I think that the police or the investigative body, be on one side of the divide, should not be allowed to go beyond the 48-hour rule.
Okay.
The person should be sent for the court to determine it.
Back to Daniel. Daniel, do you agree with this proposition by Senior Ahmed and Isaac Kankam, to the extent that after the 48 hours you are still in custody, you have been granted bail but you have not met the bail conditions, the police or the arresting institution must take you to a court?
Thank you very much, Samson. I would like to say that the 48-hour rule prescribes the maximum number of hours that a criminal suspect may be held in custody without being sent to court. And so my understanding is that if the arresting institution refuses to grant bail, they must send you to court within 48 hours. If they grant bail and you are not able to meet the conditions, they must still send you to court for the court to determine your fate. That is when the time is running beyond 48 hours. So we should not try to make artificial distinctions between those who have not been granted bail at all and those who have been granted bail but have not met their conditions. That will defeat the purpose of Article 14.3. The purpose of Article 14.3 is not about those who have just not been granted bail. The law is that the person who is not released. Now the question is, if you have been granted bail and for whatever reason you are unable to meet the bail conditions and you are still in cells or in custody, have you been released? You have not.
But the example was given. You don't share that example, that you have been given a bail condition which is not harsh, which is not excessive, which you can meet, but you are just refusing self-recognizance. Sign this document and walk away. And you say you will not sign.
Something, let us get this clear. Article 14.3 is not directed at a criminal suspect. It is directed at the institution having custody of the suspect. And so the suspect doesn't have anything to do under 14.3. It is the arresting institutions that must ensure that they do not keep an arrested person in their custody beyond 48 hours cumulatively. So when you are a police officer or arresting officer and you arrest somebody, you give the person self-recognizant bail and the person fails to take advantage, do not keep him beyond 48 hours. Send him to court and tell the court that we have released him on bail. He says he will not take advantage. So let the court deal with him. Otherwise, they will be violating Article 14.3. It is not a matter for a criminal suspect. It is a matter for the arresting institution.
So you are saying that,
and so I don't share the view that
law enforcement have been breaking Article 14.3 all these years, because once they grant you bail within 48 hours, they normally don't take you to court, whether you have met the conditions or you have not.
Yes, I would say they have been breaching the provision because once you arrest a person and you tell the person, I have granted you bail on this and this conditions, and the person is not able to meet it, if you keep that person in your custody for more than 48 hours, you are in clear breach of the provision in Article 14.3. You cannot say that because of the failure of the suspect to meet it, you have not breached. You have breached.
Okay, now hold on, Daniel. I'll return to you.
It. Otherwise,
Daniel, hold on. I'll return to you on this small bit before we close about where you said that some of the justification could be in money. You'll explain that. Yes, Sini Ahmed, you wanted to say something.
Yes, you see, when I disagree with both of them, I clearly made a distinction between an accused person technically released, but required to sign a document to go. These are conditions of bail, and it is a law that says so. Then they must set conditions for you to sign. Forget about it being harsh or onerous. If it is harsh, then my argument is that it would amount to a refusal. But if, for instance, they say, sign, provide your address, you have an address of residence, and you refuse to provide it. You say, I will not provide, I won't sign. And the policeman decides that, okay, if that is the case, the document is on the table until you sign. You don't go home. You cannot say that the 48-hour rule has been violated. That's Article 14. Now, another example. You see, we have the presumption of innocence, which says that an accused person is presumed innocent until proven guilty. Now, if a court begins to give you a hearing and you refuse to go to court, they call the case, you don't come. They call the case, you don't come. And the court proceeds to try you after many adjournments and notices to you, and you are convicted. Can you come and argue that the rules of natural justice has been breached in relation to you? Or you were presumed to be innocent and the court didn't hear from you and they prove you guilty? That is not how the law works. Much as the police have a constitutional duty to comply with Article 14 of the Constitution, an accused person has an equal duty to also make sure that when the conditions are set for his bail, which is within Article 14 of the Constitution, he must also obey it. It is a different matter if it is harsh. For that one, I will agree with them. If it is a reasonable condition, and I cited a good example, that self-recognizance, provide your house address. You have a house address, and you refuse to provide, and then you are sitting at the police station. Technically, you are the one putting yourself in the police station at that stage. It is not the police who are keeping you there.
All right.
You are keeping yourself at the police station because you are refusing to bring what you have to meet the bail condition.
Okay.
At that stage, nobody can blame the police or accuse the police of not complying with Article 14 of the Constitution. That is the argument I'm making.
Right. So, Daniel, I mentioned this earlier, and still I'm looking at Justice Dennis's book. I'm at page 178 on the matters of bail, and he speaks about deposit instead of recognizance. And at this point, he says, an order for money to be deposited as a condition for bail in lieu of surety is made in other jurisdictions depending on their laws. The position is different from the meaning of Section 99 of Act 30. The position in Ghana is that where a court admits an accused person to bail, with or without sureties, the person may, apart from the case of bond of good behavior, request the court or the officer for the sum named in the bond to be paid in lieu of executing the bond as security for the performance of the conditions imposed on that person by the court or the officer requiring the execution of the bond. Before money shall be paid as a security in lieu of executing the bond, the request for the payment of the money shall come from the person and not the court imposing that order on that person. Is that what you meant when you said money can be paid instead of documents equal the value of the money for which the bail condition has been set?
Exactly so, Samson. And we have already made it clear that the purpose of bail, with all its conditions, is to ensure the reappearance of the suspect to stand trial. So the court may require that instead of asking you to bring sureties, we are asking you to deposit this amount of money at the registry of the court, so that if you decide not to return to stand trial, the money may be forfeited to the state. That money may be imposed and may be paid either by the person himself or his sureties. And it is all aimed to ensure that the suspect or the accused person would reappear to stand trial. So money bail is also permissible. That is a deposit instead of a recognizance.
Okay.
Yes.
But as Sir Dennis explains, that must be at your election.
That is if you have the capacity to pay.
Right.
Yes, otherwise it will not make sense when you don't look at the circumstances of the accused person to know whether he or she has enough money. One of the conditions for granting bail is that the bail sum and the conditions to be fixed having due regard to the personal circumstances or situation of the suspect or the accused.
All right.
And so in money bail, the financial position of the accused or the sureties must be considered.
Thank you. Isaac,
Yes.
now, before we close, if I stand surety for you and I bring my documents to my land or my property worth the value that has been set for your bail, and then you run away. If I bring the document, what I'm telling the court is that I'm making a promise, I'm guaranteeing that the next time the court wants you, I will produce you before the court. So if I'm not able to do that, what happens to me as the surety?
Samson, previously the law was that they would do what we call expression of bond. But this is no more. There's a decision that has taken away that provision or that law now. So when you present your documents as surety and you go through the process, it is accepted as the bail document or the bail property. When you are not able to produce the accused person when it's needed by the court, the state can take action against the surety and his property for the sum that was the base sum. That's the position of the law now.
Okay. So now the position is that the guarantee that you have done is a contract between you and the state.
Yes.
So once you don't fulfill it, you will not be put into prison. What will rather happen is that they will take steps to liquidate that particular property. Is that it?
Yes.
Thank you. So, Musa, should I be afraid to stand surety for anybody? People are scared to do this, and because of that, we have those we call the professional, what do you call them? Professional sureties around some of the courts. And
bail contractors.
Yes, bail contractors. Yes, so...
Well, let me put it simple. There is no compulsion against anybody in law. It's a choice. If you want to stand trial on your own as an accused person, it's your choice. If you don't want to stand trial, it's also your choice. But the law will deal with you, whichever choice you take. Bail, we can also put a surety in the same category. A surety is someone who, on his own volition, has provided himself to stand surety for an accused person, so that that accused person, he gives an undertaking that as and when they need the accused person, he will produce the accused person. That is it. But the law does not add any word or words that you shall provide security or surety. No. It is a fundamental right. You have the freedom to do it. If you don't have the freedom to do it, you don't want to do it, you are at liberty not to do it. But if you decide to do it, then it means that you have decided to do it and there shall be no fears because you believe in yourself that you have the capacity to meet the contractual obligation that you are going to undertake with the state. So I don't think there must be any fear. More so when
I know of two friends who stood surety for their friend, and they used their houses, 2 houses, and
yes.
and the accused person ran away.
Absconded. Yes.
So the state was after their properties.
Yes. But that means that, you see, that's why I said that there is no compulsion in bail. So if you go and enter into a contract, then you must perform your responsibility or your liability under the contract.
Right.
It's a matter of contract. So there is nothing to fear. If you fear, then don't enter into a contract. It's as simple as that.
In Martin Pebu number 4, the Supreme Court, through Sophia Akufu, they held and made recommendations, including that weekends and holidays should not be a bar. I understand that we have run out of time. I want to say thank you, Daniel Korang, partner, Adum Legal Consult, Musa Ahmed, head, Ahmed Legal Consult. Thank you very much that you made time even in the circumstances you find yourself now. Isaac Kankam is head Kankam at law. And thank you very much. This has been The Law. It's your legal light. It is your help law. So even it is whether it's weekend or it is holiday, now the law is that the court can make provision for you so your bail can be heard in the court. I hope we have helped you. Have a good afternoon.